Thanks for listening in once again. You're tuned to Agriculture Today. Time once more to hear from our guest every other Wednesday here on the broadcast as he shares the latest on the agricultural law and taxation front. Roger McEowen back with us from the Washburn University School of Law. And what we wanted to draw upon this time around, Roger, a couple of decisions both made this past month by the Kansas Court of Appeals. They're different in their orientation, of course. One has to do with land valuation and what happens when family members inherit a property, but the disposition of that property isn't well split out amongst those members. Explain, if you would.
Yeah, what this is the classic problem of a partition action that's filed by children or a child after a parent dies and leaves the property to them, the farmland to them, in co-equal ownership interests. And it creates a problem. And I have mentioned this for years. I have preached on this at seminars to attorneys, to tax practitioners, to farmers and ranchers. Don't do this. Don't do this for your clients. Don't do this if you are a client. Don't set it up like this. Think of some other way to leave your farmland to the next generation so that it's not torn up and split up, because some child, most likely, is not going to want to farm, wants to cash out of that property, or wants a specific tract rather than just an equal co-ownership interest in the entire farm. It just creates a lot of problems from an estate planning standpoint, and particularly if your intent is to keep the farm intact from generation to generation. This is not the way to do it. We do not want to leave property this way, but that's what happened in this case.
This case vividly illustrates that. It originated from north central Kansas. Explain the particulars here. What happened between the siblings and the widow of one of the siblings?
Well, you had three brothers, and they each inherit an undivided co-equal interest in farmland. It's dry land, cropland, and one of the sons that inherited the property had been farming with his father for years, and he had indicated to his father that maybe we should convert this to irrigated cropland, which, of course, would increase the value of it, and they'd have to get a water permit from the state to do that so that they could divert water to run the irrigation system. And father thought that that would be a good idea, but he passed away. And the land ends up going to the three boys in co-equal, undivided ownership interests, and a very simple estate plan, very common estate plan, but it has its problems. And again, I do not advocate for this approach. And one of the brothers died, and it's the two surviving brothers and the sister-in-law, the widow of the deceased brother. And one of the brothers decides, well, I'm going to go ahead and do what Dad and I had talked about. I'm going to go ahead and get a water permit and buy some irrigation equipment. So he does get a water permit from the state, and he pays $83,000 for a 10-tower pivot irrigation system and the piping and a water meter and all of that comes along with it. And that, the court pointed out, was clearly his personal property. He had bought that property. It was his personal property. And the sister-in-law did not contribute at all to the cost of the improvements. Well, long story short, she files a partition action in court, in the local county district court, to sever the co-ownership because she wanted her share out of that. She wanted a particular tract. And of course, when you file a partition action, the court has to value the entire property and then split the proceeds equally. So now we've got three people that are involved here. We have some dry land, and now we've got some irrigated land that's worth a lot more than the dry land. So the court has to figure out what the value is. They named three parties named as commissioners, termed as commissioners, to figure out what the value of that property is. And they come up with the value of it, and it's $399,000 on the dry land and $2.065 million on the irrigated land. So you put that together, we got about $2.4 million and change, and so about $800,000 or $833,000 around in there is what her third share would be worth. Well, she says, I only want the smaller dry land tract, and the court said, well, that's worth, according to what the commissioners came up with that valued it, that's $390,000, and that's short a bit of her $833,000 that she's entitled to. So there's a sum that the court says, all right, we're going to put a sum over here. You're entitled to $428,333 to balance out your share. You're going to get this smaller tract plus that amount. And the court set aside $50,000 in an escrow account, and the other brother said, well, that $50,000 should be credited to us because that is the amount that is attributable to the improvements that we put on the land.
The argument comes in, and the rub of this case is that irrigation system an improvement on the land, though, for purposes of splitting out the value, as this sister-in-law wanted to get out.
Yeah, that's exactly what was going on. The trial court said, no, she's not entitled to the $50,000 because all we're valuing here is we're not going to value the personal property. We're just looking at the land. And the appellate court said, no, that's not the right approach here. When you change from dryland farming to irrigated cropland farming, that increases the value of the land. And so the value of the improvements, that personal property, is not the only thing to look at. What you want to look at is the enhanced value of the underlying property because now it's more productive. And so when you factor that in, the bottom line on this is that the trial court made a mistake in denying the brother's counterclaim and remanded the case back to the trial court to determine whether the trial court should award credit for the value of the irrigation equipment based on an assessment of the evidence that had been previously presented at trial. Not new evidence. It's just trial court made a mistake in evaluating the evidence, so we're going to kick it back. So this is just one of those illustrations of the problems that you can run into when you leave your property in co-equal undivided interest to your kids.
Good lesson. Court of Appeals ruling early May of this year. Another one out of the Court of Appeals for the state of Kansas. This harks back to an episode at the Kansas State Fair in 2016, and it had to do with a fitting and showing violation of livestock, or so it was declared. Explain if you would.
Yeah, it actually involved the grand champion lamb at the 2016 Kansas State Fair. And the Kansas State Fair rules bar exhibitors from treating any part of an animal's body, either internally or externally, with a substance to alter what's called conformation. So if you're changing the look of the animal by some sort of substance, either internal or external, you can't do that. That's a violation. That's called an unethical fitting. And before the fair was over, in this instance, after the lamb was crowned the grand champion, interestingly enough, and the court doesn't explain this, but this is odd, that before the fair was over, the lamb was removed from display, because normally the champions remain on display for the duration of the fair. That did not happen in this instance. The lamb was removed from display, slaughtered, and its meat was sold to market. And after it was processed, then a veterinarian analyzed the lamb's carcass and saw multiple injection marks on the back of both hind legs and associated swelling and discoloration in the muscle and the fat and abnormal reddening of the skin over those areas. And the vet concluded, based on that multiple recent injections. Now, he didn't pin down how recent those injections had been, but he just said recent injections had occurred that likely caused those abnormalities, and concluded that even though there were no drugs in the lamb's system, that there was some sort of natural substance that had been injected and led him to conclude that that altered the lamb's appearance. And the State Fair Board said, okay, that's an unethical fitting. We're going to declare this improper, and we're going to strip the lamb and the student that showed the lamb from the title as grand champion.
The disqualification here, but that exhibitor turned around and sued the State Fair Board for this action.
She did, and basically she went through two State Fair committees, and you got to go through the administrative process before you can get into court. So she went through two State Fair committees with no success and then jumped into the legal system. The trial court said, well, the vet's findings didn't provide substantial evidence as to an unethical fitting. He confirmed, the vet did, his findings of injections, but the trial court said, well, he didn't find that the lamb's appearance had been altered, and he never used the term unethical fitting, which was correct. Now, that's not really the job of the veterinarian to do that anyway, so he didn't do that. He just said, this is what I saw. You draw your own conclusions. And the court said, well, based on that, the board's decision was unsupported by the evidence, so they reinstate the championship status for the exhibitor and for the lamb. Then the State Fair Board appeals that, and that's how we got before the appellate court.
And the appellate court decided what then on this?
Well, they looked at state law, and when you go back to state law in terms of where state law, who did the legislature vest the authority to make the rules upon? And they said, that's not the veterinarian, that's the State Fair Board. The State Fair Board has the right to set the rules for the state fair, and those rules, the court said, provide a non-exhaustive list of examples of what could be considered unethical fitting. And since it's a non-exhaustive list, the court said that the State Fair Board could consider injections to be an unethical fitting, even though it's not listed in the examples that are provided in the regulations. So the appellate court reversed the trial court and said there is substantial evidence to establish that the board's decision to disqualify the lamb in accordance with the State Fair Board's rules was proper, and that an unethical fitting does not have to be attested to by a veterinarian. So the veterinarian's out. He just provided his findings. And then it's up to the State Fair Board to make a decision. The court said it's the State Fair Board that has the decision-making authority, and that's the way the legislature set it up. And that's really what this case is about.
Yeah. Well, the particulars on that case, the previous one we talked of, and many more, can be found on Roger's blog series at the Washburn University School of Law website, washburnlaw.edu/WALTR, to be more direct. As always, Roger, thank you. A pleasure.
Thank you, Eric.
Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, along with us every other week here on Agriculture Today.